Well, good morning. Happy December 16th. I'm Tara Barney. I'm the CEO of the Evansville Regional Economic Partnership, warmly known as EREP. And I'm joined this morning with my colleague, Greg Waffen, who's our president. And we were looking forward to an important conversation today. Last March, our organization stood up a system of supports to help our business and civic community deal with the onset of COVID. And here we sit nearly 2 years later, looking at what we thought was going to be a quick triage set of services to figuring out that these are the kind of services that we can provide to our members and constituents that I think are going to be an ongoing part of how we do all we can to support your businesses. So today, as we face another round of the COVID mixture, we've got different protocols coming into place. And a few months ago, the federal government took a significant action to put new regulations in place for our employer community, primarily focused on employers over 100. But again, I'm not going to get into the specifics. I'm going to take this opportunity to say that we are really grateful always to have the expertise of our members sharing their expertise with other members and constituents in our organization. And today we've got two lawyers with Dees, Donavan and Kahn, who are going to spend a little time with us, basically giving us a primer on what the new OSHA regulations require and how you as businesses can be prepared to operate within the regulations as they stand right now. So I'm especially pleased to have Olivia Robinson and Nate Golding with us. Olivia, a wave from you, please. And yes. Nate, from you, sir. We are very happy that you've given us some time this morning, and we want to get started with the presentation right away. But one quick note for everyone on this call. Feel welcome to use the chat. It's the thought bubble at the bottom of your screen if you happen to be new to this. And you can put questions in there. We probably will take them a little later in the presentation, but feel welcome to do so because we want to make sure this is a productive opportunity for everyone on the call to get as much clarity around what the regulations are as possible. So I'm going to take this opportunity to thank you all for being part of this, because the way we keep our businesses operating effectively is to share the best practices every opportunity we have. And without further ado, I think I'm going to turn this over to Olivia and Nate. Thank you both for your time this morning.
All right, hi again, everyone. As Tara stated, we are going to be talking about OSHA's emergency temporary standard. As we all know, it's dealing with the COVID-19 vaccination mandate. And so we're going to provide you as much information as we can regarding it. And again, you can put your comments in the chat or save them till the end of the presentation. So we are going to jump right in. We're going to be sharing screens, and it's going to have our PowerPoint on there for you guys to view as we speak.
All right, let's go ahead and get this up here. All right, we should have the slideshow ready to go. So as we said earlier, we'll be discussing OSHA's emergency temporary standard for the COVID-19 vaccination mandate.
So on September 9th, President Biden revealed a new national strategy to combat COVID-19. And that strategy was called the Path Out of the Pandemic. It's a 6-pronged plan. The first one focusing on vaccinating the unvaccinated, further protecting the vaccinated, keeping schools safely open, increasing testing and requiring masking, protecting our economic recovery, and improving care for those with COVID-19. So under vaccinating the unvaccinated, President Biden focused on certain industries. And the industry that we're going to be talking about today is going to be private employers with 100 or more employees. So just to give you a brief timeline of what this mandate entails is on September 9th, Department of Labor's Occupational Safety and Health Administration, better known as OSHA, would be issuing an emergency temporary standard. On October 12th, the final ETS was sent to the Office of Management and Budget for review. November 4th, the ETS was officially filed in the Office of the Federal Register. November 5th, the ETS was then published in the Federal Register and became immediately effective. Well, businesses and employees filed a lawsuit that same day against OSHA in the Fifth Circuit, alleging the ETS was unlawful for several reasons, mostly focusing on the unconstitutionality of the ETS. The next day, the Fifth Circuit entered a temporary stay on the enforcement of the ETS. November 12th, the Fifth Circuit affirmed its decision on the temporary stay after the parties had oral arguments on it. November 16th, all lawsuits opposing the ETS in various federal courts were consolidated in the Sixth Circuit. December 10th is when oral arguments began in the Sixth Circuit. And right now, a decision on whether the ETS is going to be considered legal and to go into effect is still pending. So many of you are Indiana employers, potentially employees. So we're dedicating this slide to talk about Indiana specifically as it deals with the ETS. So Indiana is an OSHA approved state plan. They actually are not governed by the federal OSHA. Indiana must, and so what that means, Indiana must either adopt the ETS or adopt a new standard that is at least as effective as the ETS by December 5th. Obviously with the with the temporary stay, they have not done so. Governor Holcomb has even stated that he directs the Indiana Department of Labor to work with the Attorney General on a lawsuit challenging the federal government regarding OSHA's ETS. So now we're just getting into what this ETS is requiring and to know whether you as an employer are covered under the ETS. And the first step in order to determine whether you're one of the covered employers under the ETS is to see if you meet the employee threshold, which as we know is 100 or more employees. So in general, the count should be done at the employer level, so firm or corporate wide, not at the individual location level. So therefore, that means for a single corporate entity with multiple locations, all employees at all locations are counted. And when we're talking about a franchisee setting, the franchisor would only count corporate employees, and each franchisee would only count employees of that individual franchise. The determination of whether an employer falls within the scope of this ETS is based on the number of the employees initially made as of the effective date of the ETS, which was November 5th of 2021. So when we're dealing with a work site or off-site locations and determining the number of employees, employers must include all employees across all of their US workplaces, regardless of the employee's vaccination status or where they are performing the work. And so when we're dealing more with like a construction type setting, part-time employees do not count towards the total number of employees, and independent contractors do not count towards the total number of employees. So as we know, with the COVID-19 pandemic, a lot of workforces went remote, or they did what would be a hybrid situation where half of their workforce is in the office, half is working remote. Well, the ETS would apply to these remote employees, but here's an example to kind of give you the specific application of the ETS. So if an employer has 150 employees, 100 of whom work from their homes full time, and 50 of whom work in the office at least part of the time, the employer would be within the scope of the ETS because it has more than 100 employees. However, the ETS's requirements would only apply to those 50 employees who work in the office at least part-time around other individuals, and it would not apply to those 100 employees working exclusively from their homes. So it would apply in the count of the employees, but as far as the ETS requirements, it would only apply to those that are in the office. So when we're dealing with temporary seasonal workers, if they are employed directly by the employer, so they're not employed from a temporary staffing agency, they are counted in determining if the employer meets the 100 employee threshold, provided they are employed at any point while the ETS is in effect. So from November 5th until the ETS is in effect. So multi-employer work sites. On a typical multi-employer work site, such as a construction site, each company represented, so the host employer, the general contractor, and each subcontractor would only need to count its own employees. And I briefly mentioned in another slide, vaccination status of your employees is not considered when you're counting the number of employees. And in addition to that, even if you have an employee or employees that have previously tested positive for COVID-19, that would not be considered when counting the number of employees. These people would still be considered within that employee threshold. So employees who exclusively work outside or outdoors. If an employer has 125 employees and 115 of them work exclusively outdoors, that employer would be covered. But the ETS requirements would only apply to those 10 employees working in the indoor settings around other individuals, not to those employees working exclusively outdoors. And OSHA has laid out very specific criteria that must be met in order to be considered an employee who exclusively works outside. So the employee must work outdoors on all days, must not routinely occupy vehicles with other employees, and works outdoors for the duration of every workday, except for de minimis use of indoor space where other individuals may be present. So we're dealing, with a multi-stall bathroom, or if the employee's just going in to pick up their check or whatnot from the administrative office. Also that needs to be noted on this is OSHA is very specific that if, for example, you have employees that are building a home, once there are walls and a ceiling, these employees are not considered working exclusively outdoors. However, if they're doing just the building of the home, the foundation, laying the foundation, building the foundation or whatnot before walls or ceilings are up, then they would fall within this threshold. So very, very specific here, but these are just the criteria that needs to be met. All right, so when we're dealing with employees who are minors, they must be counted in determining if the employer meets the 100 employee threshold for inclusion in the ETS. And minors are going to be subject to all of the ETS's requirements. When we're dealing with a unionized workplace, employers in unionized workplaces with 100 or more employees are still required to follow the minimum requirements established by the ETS. However, the employer and the union, through a collective bargaining agreement, can have, more stringent or more strict additional requirements than the ETS. But first, the employer does need to make sure that they're complying with what the collective bargaining agreement does say. For healthcare workplaces, this ETS does not apply in these type of workplaces. Healthcare workers have their own ETS. The same goes for when we're dealing with federal contractors and subcontractors. These types of individuals are already covered by the Safer Federal Workforce Task Force COVID-19 Workplace Safety Guidance for federal contractors and subcontractors. So OSHA has determined that complying with the ETS in addition to these guidelines is not necessary. For federal agencies, the same applies. The ETS does not apply to federal agencies except for the US Postal Service.
All right, so now that we know how to determine whether you have a sufficient number of employees to be governed by the ETS, we're now going to move on to discussing what needs to be included within your policy. So covered employers have two options in order that they can choose in order to be in compliance with the ETS. The first option available to employers is that they can establish, implement, and enforce a written mandatory vaccination policy. So while they can mandate that employees be vaccinated, they do need to consider that employees could potentially qualify for medical or religious exemptions if they do mandate vaccines. Alternatively, employers can also establish, implement, and enforce written policies allowing an employee not subject to a mandatory vaccination policy to choose either to be fully vaccinated against COVID-19, or if they choose not to be vaccinated, those employees can provide proof of weekly testing for COVID-19 and wear a face covering. Again, though, those employees who are unvaccinated could potentially qualify for medical or religious exemptions. So what needs to be included in the policy? The ETS has given certain guidelines that employers should follow. The employer's policy needs to be clear what's required for their COVID-19 vaccination. They need to give applicable exemptions from their written policy. So, if there's a medical contraindication, a medical necessity requiring a delay in that employee getting vaccinated, or a reasonable accommodation available for employees with disabilities or sincerely held religious practices or beliefs, those employees could be exempted, and that should be included within your policy. Other requirements include information on determining an employee's vaccination status and how that information will be collected, paid time and sick leave for vaccination purposes, notification of positive COVID-19 tests and removal of COVID-19 positive employees from the workplace, information that will be shared with employees, such as how the employer is making that information available, and disciplinary action for employees who do not abide by the policy. Additional information is when the policy's effective date begins, who the policy specifically applies to, deadlines such as when vaccine information and requirements for getting vaccinated, and procedures for compliance and enforcement. In addition to establishing the policy, an employer must also provide additional information to employees. One of the requirements is a document prepared by the CDC entitled Key Things to Know About COVID-19 Vaccines. That's available at this link. Information about protections against retaliation and discrimination, and information about laws that provide for criminal penalties for knowingly supplying false statements or documentation. So what exactly qualifies as an exemption from an employer's policy under the ETS? Examples include medical contraindications, whether the employee has a medical necessity requiring a delay in vaccination, and reasonable accommodations for employees with disabilities or sincerely held religious practices or beliefs. And we're going to go into the specifics of what's required for those. So if an employee has a disability that prevents becoming vaccinated or wearing a face covering, there's certain considerations that the employer needs to take. They should be aware that a disability is defined as a physical or mental impairment that substantially limits one or more major life activities. It's a record of a disability, or it's regarded as having a disability. So examples of those include whether the employee may have a severe allergic reaction to previous vaccines that would put them at risk of the COVID vaccine, whether they have an immunosuppression due to chronic illnesses, if they have asthma, that's a consideration to take into mind, chronic obstructive pulmonary disease, and other respiratory disabilities. This isn't an all-inclusive list, but it is, provided to give you an example of what clearly could be used as or clearly defined as a disability. What happens if your employee applies for a religious exemption? In that case, the employee, if they have a sincerely held religious practice or belief that prevents them from getting vaccinated, from being tested or wearing a face covering, there is a standard that has been established for what constitutes a sincerely held religious practice or belief. It is a broad definition, however, and Title VII protection extends beyond traditional religious or church affiliations. So while an employee may seek a religious exemption, it doesn't necessarily have to be under a traditional, mainstream religion in America. It could be something more less common, not a traditional mainstream Christian church. If an employee requests a religious accommodation, the employer has an objective basis for questioning the religious nature or the sincerity of a particular belief, observance, or practice, then that employer would be justified in seeking additional supporting information. That could be seeking a letter from an employee who's claiming an exemption. It could be seeking a letter from their deacon or priest, something to support that the employee actually is sincere in their belief. If an employee cannot be vaccinated for COVID-19 because of a medical or sincerely held religious practice or belief, then that employer has to first consider whether there's a reasonable accommodation that they can provide that employee. Examples of reasonable accommodations include weekly testing, wearing a face covering, allowing that employee to work remotely, separating non-vaccinated employees from vaccinated employees, moving that employee's work area to comparable areas that are less congested, temporary leave under FMLA, paid time off, et cetera. The key here, though, is that it's very fact specific. So what's going to constitute a reasonable accommodation is going to be very specific under the employer and employee's specific circumstances. Key to determining whether they can provide a reasonable accommodation is that the employer and employee must engage in what's called an interactive process in order to identify whether a reasonable accommodation would or would not constitute an undue hardship on the employer. So what goes into making up an interactive process? Well, it includes recognizing that an accommodation request has been made, gathering the information necessary to process that request, exploring accommodation options, choosing an accommodation that's appropriate for both the employee and the employer, and then finally implementing that accommodation. Key to this process, though, is communication on part of both the employer and the employee, and the willingness to consider alternative solutions. So following is a list that includes acceptable documentation for proof of vaccination under the ETS, a record of immunization from a healthcare provider or pharmacy, a copy of a COVID vaccination record card, a copy of medical records documenting the vaccination, copy of immunization records from a public health, state, or tribal immunization information system, or a copy of any other official documentation that contains the type of vaccine administered, dates of administration, and the name of the healthcare professionals or clinic sites administering the vaccine. It's key that the employer retain either a physical or digital copy of the employee's vaccination record, so that there is a record holding requirement there on employers. If the employee does not possess a vaccination record, then they must provide a signed and dated statement attesting to their vaccination status, so they could be considered either fully or partially vaccinated, the type of vaccine they would have received, date of administration, and name of healthcare professional or site administering the vaccine. They would also want to attest that the employee lost or otherwise is unable to provide proof of vaccination. And they would want to include the following language: I declare or certify, verify, or state that this statement about my vaccination status is true and accurate. I understand that knowingly providing false information regarding my vaccination status on this form may subject me to criminal penalties. Employers are also required to maintain a roster of employee vaccination status. This roster should include a list of all employees and clearly indicate for each whether that employee is fully or partially vaccinated, not fully vaccinated because of a medical or religious accommodation, or not fully vaccinated because they've not provided acceptable proof of vaccination status. The records and roster required by the ETS are considered confidential though, so they need to be protected and not available for access unless there's a justification for it. Finally, we'll discuss some additional considerations employers should keep. For time spent getting vaccinated, the employer must provide up to 4 hours of paid time off at the employee's regular rate of pay in order for them to get vaccinated. Key to this is that employers cannot require employees use PTO or sick leave to get vaccinated. So this is, an additional payment that should be made for the employees if they are spending time at work getting vaccinated. Time to recover from vaccine side effects, employers must also provide reasonable time and sick paid leave to recover. If an employee has already accrued paid sick leave, then the employer in that case may require the employee to use paid sick leave when recovering. Transportation costs, employers are not required to reimburse employees for costs incurred to receive the vaccination.
So employers must ensure that each employee who is not fully vaccinated complies with the ETS testing requirements. And the testing requirements are an employee who reports at least once every 7 days to a workplace where other coworkers or customers are present, must be tested once every 7 days, and must provide proof of the most recent COVID test no later than the 7th day following the date on which the employee last provided a test result. The employer cannot require an employee who had previously tested positive for COVID to undergo testing for at least 90 days following the date of the employee's positive test or diagnosis. The employer must maintain a record of each employee's test results, and these records constitute confidential medical records. So who pays for the cost of this testing? Well, employers are not required to pay for any costs associated with the testing. However, there may be a state, local law, regulation, or a collective bargaining agreement that says otherwise. I have an example here of Kentucky. Kentucky does not require employees to pay for COVID-19 testing if it's required by their employer. There are other states that have similar laws. Indiana is not one of them though. Employer is required to comply with the testing requirement as long as the ETS is in effect. So under the ETS, a COVID-19 test must be a test for SARS-CoV-2 that is cleared, approved, or authorized, including in an emergency use authorization by the U.S. Food and Drug Administration to detect current infection with the SARS-CoV-2 virus. So an example is a viral test, must be administered in accordance with the authorized instructions, and not both self-administered and self-read unless observed by the employer or an authorized telehealth proctor. So here's some examples. Tests with specimens that are processed by a laboratory, including home or on-site collected specimens, which are processed either individually or as a pooled specimens. Proctored over-the-counter tests, point of care tests, and tests where specimen collection and processing is either done or observed by the employer. Antibody tests do not meet the definition of COVID tests for the purposes of this ETS. So when you have the situation where an employee tests positive, the ETS is requiring that the employer remove this employee from the workplace. So they must immediately removed if they received a positive test or diagnosed by a licensed healthcare provider, and the employer must be keeping that employee away from the workplace until that employee receives a negative test results, meets the return to work criteria under the CDC's isolation guidance, or receives a recommendation to return to work from a licensed healthcare provider. An employer is not required to remove unvaccinated employees if they have been exposed to a COVID-19 positive person. So they're not requiring those employees that have come in close contact with someone that has tested positive for COVID-19. All unvaccinated employees must wear face coverings and submit to weekly COVID-19 tests, but employers are only required to remove employees if they've tested positive for or been diagnosed with COVID-19. Employers are not required to provide PTO to any employee for removal as a result of testing positive or receiving a diagnosis of COVID-19. But again, there may be a state or local law, regulation, or collective bargaining agreement that says otherwise. So you want to make sure that you're aware of any of those potential state or local laws or collective bargaining agreement. Anytime an employee is required to be removed from the workplace, the employer can require the employee to work remotely or in isolation if suitable work is available and the employee is not too ill to work. If the employee is outside of the workplace when he or she receives a positive test or diagnosis, he or she must promptly notify the employer. And the ETS defines what promptly notify means in this context. It means as soon as practicable before the employee starts his or her shift or returns to work. In the situation where the employee is in the workplace, when he or she receives a positive test or diagnosis, the employee must notify the employer as soon as safely possible while avoiding exposing any other individuals in the workplace. Employers are not required to conduct contact tracing if an employee tests positive or is diagnosed with COVID-19. The employer is not required to establish or maintain records of employee notifications of a COVID-19 test, a positive test or diagnosis by a licensed healthcare provider. If the employer determines that a reported case of COVID-19 is work-related, the employer must record that information on the OSHA forms 300, 300A, 301, or on any equivalent form if required to do so under federal law. And those forms can be found directly on OSHA's website. Employers are required to provide employees with access to their COVID-19 test records if the employee asks for them. The employer has to make these records available for examination and or copying within the next business day after a request. They are not allowed to remove those records from where those records are kept. So they may be in the HR's office, but they are allowed to examine and make copies of them.
All right, so now let's discuss face covering requirements for unvaccinated employees. Only employees who are not fully vaccinated are required to wear a face covering when indoors and when occupying a vehicle with another person for work purposes. There are exceptions to that requirement, however, such as when an employee is alone in a room, when there's floor to ceiling walls and closed door, while the employee is eating, drinking at work for identification purposes, when the employee is wearing a respirator or face mask, or where the employee can show the use of a face covering is infeasible or creates a greater hazard. So the cost of face coverings, employers generally are not required to pay for any costs associated with face coverings under the ETS. But like we discussed earlier, that could be modified by state or local laws, regulations, or collective bargaining agreements. So while the ETS itself places that burden on the employees to cover the cost of face coverings, employers do need to be aware that that could change based off of their jurisdiction. So what are the reporting requirements for COVID-19 fatalities and hospitalizations? Employers are only required to report work-related COVID-19 fatalities and inpatient hospitalization to OSHA by telephone or by electronic submission. Here's the key compliance dates that were issued with the ETS on November 5th. It really needs to be noted and emphasized, though, that these dates are kind of in flux right now due to the legal challenges and with the ETS currently being stayed. So while these dates were, on track when it was initially published, at this point, while it's being challenged, it's difficult to say how the court will rule on some of these requirements. So while it's possible some of these requirements may no longer be in place after the Sixth Circuit issues its ruling, and it should be noted that both sides on this argument have indicated they will challenge this to the Supreme Court. So, the Sixth Circuit's decision likely will, only be temporary, at least until the Supreme Court hears it. It is a good general policy to be sure that you're ready to implement these requirements after the courts have issued their rulings, should they still be in place. So familiarize yourself with some of these requirements. The key one at this point is that employees who are not fully vaccinated are to be tested for COVID at least weekly and wear face masks. It was to begin January 5th of 2022, but now, like we indicated, it's kind of in flux right now. So there are different compliance dates based off of the type of vaccine, because the timing of doses for the 3 main vaccination series available in the United States is different. Employers and employees should keep in mind the following dates. For the Johnson & Johnson vaccine, since it's only 1 dose, employees who receive it must get their first dose on or before January 4th. For the Pfizer vaccine, since it takes 21 days to complete and obtain primary vaccination, employees receiving it must receive their first dose on or before December 14th and get their second dose by January 4th. And then for the Moderna vaccine, since it takes 28 days to complete, employees receiving Moderna were to have gotten their first dose on or before December 7th and get their second dose by January 4th. So the date in which the ETS is to be in effect was to be 6 months after its publication on November 5th. So it's key that the courts, since it's being challenged, that implementation period likely will be sufficiently less than 6 months. Penalties for noncompliance. Failure to implement and enforce the requirements of the ETS could result in potential citation and fines of up to $13,653 for each serious violation. And then you could be subject to $136,532 for each willful or repeated violation. So there is a heavy fine for willful or repeated violations. So I guess we kind of already discussed this a little bit, but what now should employers keep in their minds? Since the ETS is temporarily stayed and its fate will be decided by the Sixth Circuit soon, it has been indicated that either party is likely to appeal that decision to the Supreme Court. Covered employees, though, should still plan on how to implement the ETS in the event that it becomes effective. I think returning to that a little bit, the Sixth Circuit, it does have a fairly conservative membership. Supreme Court as well. It's while we can't make any predictions with certainty, it is likely that the ETS will not remain in its current form after these legal challenges. But again, it's a good practice to prepare in the event that they are upheld as is, so you'd be ready to implement those policies.
And as you can see from our presentation, there are very specific requirements, very specific guidelines that you would need to follow in the event that the ETS does be considered legal or becomes effective. So you just want to make sure that you're prepared versus unprepared in this situation. And it looks like we have maybe 2 comments in the chat.
Yeah, I think there's a couple questions out there. I'll maybe read them back to you, but I'll also encourage anyone that's on the call that has additional questions. Now's the time. But one is from Lori. Lori, do you want to repeat the question? You can unmute yourself if you wish, or I'll read it.
Yes.
Okay.
So my question, I just wanted to confirm. So employees are able to have copies of their tests. They can request that, and we could make a copy, and they can remove the copy with them.
Correct, but just not the, I guess,
the
original. Correct. You still have to maintain either the original, or at least,
Sure.
I guess if they have the original, you have to retain a copy. But yes, they cannot take, I guess, the employer's copy of that
Sure.
documentation. Yeah.
Thank you.
Absolutely. And then I think some people are wondering if we will be emailing this presentation out. We absolutely can. Absolutely.
I think that would be helpful because there's some important links in there that I think everyone would like to have. And it's a good primer as everyone's trying to absorb this.
Right. Right.
Other questions or comments about what's coming or what's at least on the books right now until we hear from the courts?
I have one more follow-up question, and I apologize, I had to take a call when the slide was up, but did I read that it talked about positive employees who receive a positive test result then would need to have a negative test result before they return to work? That's not correct, right?
It's either they meet the CDC guidelines for the criteria for coming back to work, or they provide a negative test result, or they're basically released from their licensed healthcare provider.
Okay.
Like a note. Yes. So there's 3 options for them to come back to the workplace.
Thank you.
Absolutely.
Well, I know we have quite a few businesses that are fall into this potential regulatory space. And so to all of you businesses, we certainly want to hear from you as you begin to execute or to follow up on these regulations as we get into the new year. It's fair to say that the Indiana legislature has made some indications they'll be acting in this space, and that's certainly not the subject of our call today, but I would take this opportunity to let businesses on this call let us know that we always want to hear from you about the impacts or what your circumstances are, so we can have a good read of how to be helpful in building good business-friendly public policy around these many twists and turns that are coming and how we navigate both public health and business productivity and personal freedoms. And so there's a connection there somewhere, and we will continue to do all we can to make sure that our constituents have the best information they can as we find our way through this process. So I'm looking at the chat once more, or if anybody has a question and isn't using the chat, you're welcome to speak up now. Well, our follow-ups will be these. First of all, thank you both, Olivia, Nate. It's good to have expertise in our region on these complex matters. I know that because there's so much there, getting this slide deck out to everyone will be welcome. But I'd also share with everyone on this call that we record these, so the recording of the whole thing will be available if you just want to hear the additional commentary that Olivia and Nate offered. We'll have it on our website. And so you can always refer back to that as you're trying to remember exactly what they said about outdoor workers or underage workers, or some of those criteria that I know are pretty complicated within the slide deck. But it's a lot of information. And so we are very grateful to you, and not just to you and to Dees, Donavan and Kahn, but also to every one of the employers on this call that's taking the time to make sure that you're managing your work environment and your operations, not only to the best possible impact for your business, but also for your employees. So we appreciate everyone's deliberate efforts in this space. I've said this on calls for many, many months now, but I'll say it again. So we are all doing what we can to make sure that we move through this with a good even balance, and to keep our businesses operating and active. And so thank you for your time this morning. And to everyone on this call, I hope you have a lovely holiday season. And please stay in close touch with me and with the EREP staff, with Greg and others, as circumstances come up with your businesses that that we might not have anticipated that we can be helpful for, because that's always our number one priority when we get up every day. So happy holidays to you all. And I'm going to give you back a little time for your day, but many thanks to you all for being on the call, and Olivia and Nate, once again, great information.